Good morning, dear ladies and gentlemen, dear colleagues. It is a great pleasure to welcome you at the opening of this two-day hybrid international conference on secondary sanctions organized jointly by GRILI, the Ghent Rollin Jacquemin International Law Institute, and Renforce, the Utrecht Center for Enforcement and Regulation in Europe. As I stand here before you, it is clear that the group of persons physically present at the conference venue is ultimately a smaller one than initially envisaged. Ironically, this conference was originally meant to have taken place 1 year ago in December 2020, but was at the time postponed due to the COVID pandemic in the naive belief that the situation would have sufficiently improved to permit an old-fashioned in-person dynamic exchange of views. Unfortunately, reality has caught up with those aspirations. As this country became, like many others, engulfed by a fourth wave of COVID infections, numerous panelists and participants have indeed understandably informed us in recent days that they would ultimately be unable to join us in person in our beautiful city of Ghent. Fortunately, of course, we still have a hybrid event with many of you joining us online. And so, notwithstanding some organizational hiccups, we are still delighted to present an exquisite lineup of expert speakers, including some of whom will be joining, for instance, from the United States or China, in spite of the obvious time differences, something for which we are particularly grateful. All the same, it is a pleasure to welcome a diverse audience of participants in person and online, consisting of scholars, practitioners, and civil servants alike, which we hope will benefit from and contribute to our discussion. 1 year after this conference was originally meant to have taken place, the topic at hand remains equally relevant. Indeed, having boomed in the last 2 decades, unilateral or non-UN sanctions have become an important instrument in the foreign policy toolbox of numerous states, and a phenomenon almost as omnipresent as COVID-19 perhaps. While the efficiency and legality of unilateral sanctions have been the subject of ample debate, this conference zooms in on a specific and particularly challenging subset of such sanctions, that is, secondary sanctions. Clearly, while the term secondary sanctions does not have an established legal meaning, it is increasingly used to describe those sanctions by which a sanctioning state, first and foremost the United States, seeks to restrict trade, not so much between its own nationals and companies and those of the primary sanctions target, but rather between third country nationals and companies and the country that is the primary sanctions target, as well as its nationals and companies. Part of a broader trend towards the weaponization of international trade and finance, they serve as a force multiplier for states' primary sanctions, essentially forcing foreign companies to choose between doing business with the sanctioning state and the primary sanctions target. As the United States sanctions regime against Iran amply illustrates, their impact can be enormous. Figures of the European Council for Foreign Relations suggest that since 2018, US extraterritorial sanctions against Iran have cost EU businesses some 20 billion euros in direct losses. This is all the more surprising in as much as the so-called EU blocking statute in principle prohibits EU companies from complying with a range of extraterritorial US sanctions, including those targeting Iran. It is no wonder then that third countries often perceive of secondary sanctions as a threat to their economic and political sovereignty. Leaving aside their impact on third countries, the effect of secondary sanctions on the economy of the country constituting the primary sanctions target is, of course, far greater. Notwithstanding, for instance, OFAC's use of exemptions, this also raises fundamental humanitarian and human rights concerns, a point repeatedly emphasized by the UN Special Rapporteur on unilateral coercive measures, who is also joining us today. Furthermore, a key feature of secondary sanctions is the degree of overcompliance. This phenomenon flows from the sheer complexity and intransparency of the relevant regulatory framework, combined with the enormous risk of third country operators committing a breach, whether in the form of massive administrative fines or exclusion from the United States market. secondary sanctions essentially operate as tools of deterrence. As one US colleague recently labeled them, they can be seen as a form of creating chaos at bargain rates. While the use of secondary sanctions is primarily associated with the United States, there is a genuine concern that other countries will follow suit in future years. Already, some point towards an increasingly assertive extraterritorial posture on the part of China. For its own part, while the European Union occasionally claims not to adopt extraterritorial sanctions, its actual practice may suggest otherwise, as is, for instance, illustrated by the recent threat of sanctions targeting airlines operating between Belarus and third countries. From an international law perspective, secondary sanctions present something of a catch-22. For instance, in the case currently pending before the International Court of Justice between the United States and Iran, the United States has explicitly argued that their third country dimension means that the sanctions reimposed after the US withdrawal from the Iran nuclear deal means that they cannot infringe the provisions of the bilateral treaty of friendship that was concluded between the United States and the Islamic Republic of Iran in 1955. Of course, then the question still remains whether they may nonetheless contravene bilateral or multilateral treaties applicable in the relationship between the sanctioning states and impacted third countries, such as investment treaties or trade agreements within or without the World Trade Organization. Furthermore, to what extent does general international law restrict the imposition of secondary sanctions, having regard to the principle of non-intervention and the customary rules on the exercise of jurisdiction? For instance, does the mere clearing of a dollar transaction between non-US parties through a correspondent bank account in the US present a sufficient nexus with that country to exercise jurisdiction? These are some of the burning questions that will be addressed over the course of these 2 days. In 6 panels, we will indeed look at the concept of secondary sanctions and their impact, including on trade and finance, their compatibility with law of jurisdiction and various facets of international economic law, as well as their role in domestic litigation. A final panel will take a look ahead, also addressing how third states impacted by secondary sanctions may respond to them or do respond to them, including but not exclusively at the EU level. Having sketched the aim of our gathering in broad strokes, I would like to take a minute to express my sincere gratitude for those that have helped in organizing this event in challenging circumstances, including first and foremost my dear colleague and friend Cedric Rijngaard from Utrecht University, as well as fellow co-organizers Alexandra Hofer, also from Utrecht, Nicolas Angelet from the University Libre de Bruxelles, and Frédéric Dopagne from the Université Catholique de Louvain-la-Neuve, who would have loved to attend, but who unfortunately fell ill a few days ago. We are also grateful for the funding generously provided by the Fund for Scientific Research Flanders and the Fonds National de Recherche Scientifique. For practical and administrative coordination and IT support, I wish to thank the inimitable Christine Ballegeer, our in-house crisis management expert, as well as Peter van Damme for the IT support and Felipe Rodriguez Gonzalez, together with other colleagues from Grilli. Last but not least, it is of course a pleasure and honor to introduce to you our keynote speaker for today. As mentioned earlier, our final panel will, among other things, address the EU perspective on and response to secondary sanctions, an issue that is particularly acute in light of the EU's ongoing revision of the blocking statute and its preparatory work on a so-called anti-coercion instrument. Lifting a tip of the veil, this EU perspective is also where we begin our 2-day journey. And the perfect person to set the stage for that journey is Dr. Lucio Giusetti. Dr. Giusetti has a long and rich career as a member of the European Commission's legal service, as member of the private office of the President of the European Commission, and as director of the Committee of Regions. Since 2011, he acts as director and principal legal advisor of the European Commission for Foreign Security Policy and External Relations. Dr. Giusetti, thank you very much for joining us online. The floor is yours.
Tom, I hope you all can hear me. Let me start first for thanking you personally and the beautiful city of Ghent and its university for inviting me to this event. Second, let me apologize for not being present in person, but this is really unexpected. I am just running on paracetamol at this point, but I really wanted not to miss this opportunity. I promised it to you and I wanted to keep my vows and word. Here I am. Let me start also this presentation with a very old anecdote, a personal anecdote. Many, many years ago, I was traveling in the north of Australia, and I was driving in the middle of the bush, the outback over there. And then I was warned about the law that applies to that part of the country, or at least applied to the part of the country called the might is the right. I didn't understand it when I was told what that meant. And then while driving, I was bypassed or surpassed or exchanged with the road trains that are huge tracks over 40, 50 meters long that drive at 70, 80 kilometers per hour on gravel roads. And if you don't pull out and stop, you are simply crushed. That is what might is the right is. I learned that lesson and I keep it in my mind while using my limited tools of intelligence in my work as lawyer for the European Commission. Now, why am I quoting this? This anecdote is obvious. It is obvious because in recent years, a number of countries have increased their use of sanctions and regulatory measures to restrict also in EU individuals or companies. The EU has done the same and is doing the same as a regular tool of its foreign policy. There are sanctions that apply to foreign persons and entities for activities carried out outside our jurisdiction. Yes, they are, but they continue to have a jurisdictional nexus with our activity. So why are we now convened to this conference? Because there is a practice that is now developing, and worryingly so, of what is called the secondary sanctions. Sanctions that apply outside the jurisdiction of the state that takes them, and there is no sufficient nexus that triggers those sanctions. In fact, if I refer immediately to our present and most immediate concern, for example, the US apply sanctions just by using the trigger of the US dollar and the US financial system. That is the starting point of what I will say today. As Tom was referring a minute ago, the damage caused by US sanctions on the EU and its economic operators is a significant challenge, not only in terms of cost, and it is a very high cost, but also in terms of political concern for the EU. The topic of this conference is very timely. Here we have a coincidence of three events that require our attention. The EU is subject to pressures to start thinking along the same lines. And believe me, inside the Commission and elsewhere, there are a lot of resistances to that attempt. Second, the US, notwithstanding the change of the president, haven't changed tack, at least for the time being, save for some minor details. And that is also an important point to be kept in mind. Third, there is ongoing a revision of the blocking statute, something that Tom has referred to as well in his presentation. I will address now, but therefore, in three parts, the elements that contain what is going on. First, what is happening today. Second, the legal challenges that are present to us in the application of the blocking statute. And third, some initial views of the revision of that instrument. The tensions in this area have increased since 2018, when the US unilaterally decided to withdraw from the Joint Comprehensive Plan of Action, the JCPOA treaty with Iran. It also reactivated its unilateral sanctions, which had committed to lift under the deal. Under the US National Defense Authorization Act for fiscal year 2012, foreign financial institutions may not knowingly conduct or facilitate any significant financial transaction with the Central Bank of Iran or any other designated Iranian financial institution. Such foreign financial institutions are prohibited from maintaining correspondent accounts in the US, with only strict limited exceptions. In light of the importance and broad use of the US dollar in payments and of the US banking system, the scope of this sanction is in practice very extensive, and to our understanding and analysis, abusively so. In fact, the US seems to be trying to disguise this unlawful extraterritorial effect by claiming that the US protects vital interests of its own country, using this argument to shade or to trying to shade from the extraterritorial application. In May 2019, 2 years ago, the US also ceased to waive some provisions of the Cuban Liberty and Democratic Solidarity Act of 1996, the so-called Helms-Burton Act. This act, among other things, allows for legal proceedings against persons that traffic in property expropriated by the Cuban regime. You may remember that the blocking statute was triggered by the adoption of the Helms-Burton Act. This law has made it possible for US plaintiffs to initiate actions against foreign entities that may have directly or indirectly benefited from any commercial activity in the confiscated property, even if such entities have no relevant activities in the US, or those activities have no nexus whatsoever to Cuba. Some district courts have dismissed, and this is a good news, several suits for lack of personal jurisdiction, recognizing the need
It seems we have momentarily lost our keynote speaker due to connection problems, but please bear with me as he seeks to reconnect. We'll wait for a short minute.
Do you hear me again? Hello?
Yes, we do.
I am very sorry, but it's snowing heavily in Brussels at this point, and we had a small blackout, apparently, and I was disconnected completely. So my apologies for this short interruption. I will take from where I was presenting. The good news, I was saying, is that the district courts have dismissed several suits for lack of personal jurisdiction, recognizing the need of a nexus between the defendant state and the state in which the court sits. This is really good news, because the rule of law applies obviously in a democratic country like the US. And therefore, these judgments limit the number of cases initiated against the EU operators. However, there are still some pending cases. So the battle is not won at all. There are too many examples of extraterritorial application of US sanctions against the EU interest, but not the only ones. In June 2020, the Trump administration decided to sanction the ICC prosecutor Bensouda and the head of jurisdiction, complementary and cooperation division of the ICC, Mochochoko. I am not going to dwell with the political impact of such a decision. This is not for me and not for this conference, possibly, but in any event, this is not for me to comment on. What it is for me to comment on is that what was less clear to a lot of interlocutors in my exchanges during when these decisions were taken is that these sanctions also hit indirectly EU companies, insurance companies, EU banks that were providing, for example, for bank accounts for these two persons. EU officials may have been targeted. Fortunately, these measures have been lifted recently, but they've lasted for a sufficient time to be very significantly, I would say, negative in the way we have apprehended our relations with the US. Now, the fact that the US have now changed this is really a reason for satisfaction for us. So even if the new administration has shown more willingness to return to the multilateral fora, 10 days ago, the US announced new sanctions against entities involved in the Nord Stream 2 gas pipeline, a project designed to bring natural gas from Russia to Europe. There is no need to explain why the overall objective is to deter EU companies from participating in a project that has no nexus with the United States jurisdictions or territory at all. Again, my comment is limited to the sanctions and to their effects. I'm not at all going to comment nor enter into any appreciation of the project itself. That's a separate issue. According to international law, states have jurisdiction to legislate and enforce laws with regard to their nationals and entities established under their legislation, activities carried out within their territory, in limited circumstances, activities which can have a damaging impact on the national interest of the state when there is a sufficient nexus between that activity and the state's national interest, and 4, some crimes defined by international law which are subject to universal jurisdiction. These 4 elements, I think, are a common ground for everybody in the world, save some very limited exceptions. Within these limits, international law does not prevent national legislation from having certain extraterritorial effects. However, extraterritorial effects of national legislation that go beyond these limits are simply unlawful and break the principle of committee that regulates the existence of 190 and more countries in the world in a limited space like the Earth. It is relevant to recall that the EU has developed a solid and consistent framework of restrictive measures, and we are aiming at improving its implementation and enforcement in the future. However, the EU only imposes restrictive measures on EU and non-EU nationals or entities when there is a legitimate nexus with the EU. As a matter of principle, the EU considers the extraterritorial application of sanctions contrary to international law. The measures mentioned above, or simply the threat of imposing them, that's the other element, the over-compliance Tom was referring to, have resulted in significant economic damage to the EU economy. The US sanctions impinge both in the EU's economic sovereignty and on the healthy development of European business based on the single currency, the euro. Finding a way to shield the EU entities, especially banks, from US territorial sanction is thus of major importance and an absolute political priority for the EU. So let me now spend a few words, as indicated earlier, to the EU present response to this behavior. The EU, after the 1996 Helms-Burton Act, has adopted the so-called blocking statute, a regulation that basically frames a number of legal reactions to that act when that act has secondary effects on the EU economy or operators. The blocking statute aims at countering the unlawful effects of third country extraterritorial sanctions on EU operators and to protect EU operators engaging in lawful international trade and or movement of capital, as well as related commercial activities with third countries in accordance with EU law. It also seeks to protect the national sovereignties of member states. On the contrary, the blocking statute is not intended to protect third country companies directly targeted by the US measures. That's a very important point. Again, we do not want to regulate outside the EU jurisdiction. How does it work? The EU operators are prohibited from complying with the legislation listed in its annex or with any decision, ruling, or award based thereon, given that the EU does not recognize its applicability to or effects towards EU operators. The annex currently only contains US laws regarding sanctions against Iran and Cuba, but other sanction regimes may be added as needed, if needed. So this is an open-ended instrument that can be applied whenever necessary. A mandatory reporting system is introduced in cases where the economic or financing interests of EU operators are affected by the listed laws. EU operators can recover in court any damages caused by the extraterritorial application of the specified foreign laws from any person or entity causing the damages. This is Article 6. And member states are obliged, of the Union, are obliged to provide for effective, proportionate, and dissuasive sanctions in the event of a breach of the blocking statute. This is Article 9. Exceptionally, Article 5, Paragraph 2 of the blocking statute allows compliance to be authorized by the Commission in case non-compliance seriously damages the interests of the operators or of the Union. The Commission implementing Regulation 218/1101 sets out a number of specific criteria to be taken into account by the Commission when granting or denying an authorization to comply with US secondary sanctions. In that regard, any applicant must carefully consider whether these criteria are met before lodging any application with the Commission. Assessments of this request take approximately 6 months, although in duly justified cases of urgency, the period can be shortened significantly. The Commission is in regular contact with companies. They write to us, they call us regularly in order to guide them on the need to submit application and applicable procedures. A guidance note was published by the Commission in the official journal, so it's available publicly, at the end of 2018 in order to guide EU economic operators. Let me now turn to the legal challenges. I think this is also of interest of yours when discussing this and having your debates in the following hours. The legal challenges we've been confronted with in the application of the blocking statute. The EU courts, the top court and the general court, will adopt in the coming months 2 judgments that for the first time will interpret the blocking statute. So I will be expressing certain appreciations that are sub judice. So consider that I may be wrong, we may be wrong, and this is life for a lawyer. Those judgments are expected to provide more guidance as regards the scope, the limits, and requirements for application of the blocking statute. Let me share with you three of the controversial legal issues we have been confronted with in the application of the blocking statute. The first one, the need to prove the causation of a serious damage to the interest of the EU operator or those of the Union. The second, the scope of the prohibition under Article 5.1, which triggers the sanctions under Article 5.9. And C, the rights of third parties that are affected by the measures, including by the lifting of the obligation through the exceptions under Article 5.2. So on the first one, the need to prove causation of a serious damage to the interest of the EU operators and of those of the Union. Article 5.2 of the blocking statute introduces an exception to the general rule, and thus, in accordance with the ECJ constant jurisprudence, the Commission interprets that provision strictly. Such a departure from the rule requires a sufficient, express, and legally sound motivation, which in turn shall be grounded on solid evidence. The existence of a proven damage is not per se sufficient to justify a derogation. The damage needs to reach the threshold of seriousness, as per Article 5.2. The risk of the applicant incurring civil or criminal liability, financial losses, or other negative consequences from non-compliance with the US legislation at stake does not prove per se the presence of a serious damage to its interests, or all the more to those of the Union. This additional element needs therefore to be motivated and proven separately and in addition to the existence of the damage itself. Article 4 of the implementing regulation I mentioned earlier provides for some criteria to assess whether a serious damage did arise. It is also relevant to take into consideration the scope of the authorization requested. In this respect, partial authorizations, for example, to appear before US courts to defend themselves or to request the dismissal of the case for lack of jurisdiction, may be easy to justify based on the need to protect the applicant's right of defense, recognizing Article 48 of the Charter of Fundamental Rights of the European Union, or if you wish, Article 6 of the European Convention on Human Rights. The second legal issue is concerned with the scope of the provision of under Article 5.1 of the blocking statute. And this is more specifically in the context of a private transaction. The ECJ was recently requested to interpret the blocking statute in case C-12420, Bank Melli, Iran. This is the first time the ECJ is being asked to give a preliminary ruling on the interpretation of the blocking statute. In particular, the referring court asked whether the blocking statute only applied where an administrative or judicial authority of the US had addressed directly or indirectly some instruction to the EU operator, or whether it was sufficient for the EU operator to spontaneously comply with a foreign extraterritorial legislation. You see, this is very important. It's the behavior or the trigger. On March 12 of this year, the Advocate General that issues an opinion before the court, a non-binding opinion, but it is important and there is a significant likelihood that the court might follow it. So issued its opinion in this case where it confirmed the broad interpretation of the obligation under the blocking statute by stating that it applies to any action taken to comply with any of those US laws, and I quote, even in the absence of instructions or requests by an administrative or judicial body. This is in paragraph 65 of the opinion of the Advocate General. Therefore, the Advocate General considered that if an EU operator terminates a contract because the counterparty was sanctioned under one of the relevant US laws, it may be in violation of the blocking statute, even if the authorities of the US did not order the EU operator to terminate the contract. Otherwise, that's the underlying logic of the Advocate General, the effectiveness of the blocking statute would be undermined, since in practice, most, if not all, EU operators would comply with US sanctions even in the absence of a prior request by the US authorities. The over-compliance, once again, to which Tom very rightly referred to. The Advocate General also considered that if under the relevant national legislation, the EU operator was entitled to terminate the contract with the US sanctioned entity under the laws listed in the blocking statute without cause, the EU operator was obliged to state the reasons for the termination of the contract. Cause, since the Roman times, over 2,000 years ago, is one of the constituting elements of a contract. So this is, again, something that needs to be taken into account in the logic of the blocking statute that refers to private operators that have civil law relations. According to the Advocate General in its paragraph 89, the EU operator should have the burden to prove that the termination of the contract was justified in reasons other than compliance with EU sanctions. As said before, we need to wait for the court before drawing any conclusion. But it is interesting the kind of debate which is going on and the reasons that are proposed in order to take one position or the opposite. Now we move to the third controversial issue, the right of third parties in the authorization procedure under Article 5, Paragraph 2 of the blocking statute. That regulation does not expressly recognize any rights to persons subject to US sanctions to ensure that their views on interest are considered in the context of an authorization decision to lift the prohibition to apply the sanctions. In fact, as said before, the blocking statute is aimed at protecting EU operators. So that logic of the legislator is consistent. Despite that, the Advocate General in paragraph 75 of the opinion I just quoted in Bank Meli Iran stated that the blocking statute must be interpreted as conferring certain rights in favor of persons subject to US sanctions, among others, the right of a direct action to request compliance with the blocking statute. This question is likely to be analyzed in more detail in another case that is currently pending before the General Court, the lower level of the EU courts. In this case, the claimant, an entity that was sanctioned by the US and negatively affected by a 5-2 authorization decision of the Commission, has alleged an infringement of its right to be heard in the process of adoption of such decision. As a lawyer, a private lawyer, probably I would have done the same. In its final judgment, the General Court is likely to analyze, therefore, the need, what are the rights of the third parties subject to the US sanctions that are individually affected by an authorization, and in particular, whether those parties enjoy a right to be heard in the process of adoption of the decision. So the two elements, be heard during the procedure of 5-2, and on top, the possibility of bringing cases in order to impose implementation of the blocking statute or ask for the operators to be subject to the blocking statute if they don't do it voluntarily. So these are the two aspects that are sub judice. I will refrain from taking any position on this because we simply wait for the judgments. As the Advocate General has already provided with his opinion, my expectations are that the judgment of the main court will arrive sometime during spring, so pretty soon. Finally, I would like to share with you the state of our current review of the blocking statute. the policy options that are considered, and the timeline for adoption of a proposal of amendment. We are confronted to a situation as described, which is not completely satisfactory. Compliance by EU operators and enforcement by the member states of the European Union is currently not particularly brilliant. This is largely due to the relevance and importance of the US financial system in the global affairs. The EU operators often consider it to be greater risk to comply fully with the blocking statute, thereby risking their access to the US financial system, rather than just ceasing to comply with US sanctions and continuing their legitimate business, for example, with Iran or Cuba, or Cuban entities, rather. Indeed, the blocking statute thus sometimes incentivizes, this is the paradoxical situation in which we are, the economic policy unique to each member state, fueling a negative loop in the operation of the EU internal market. Why that? Because companies try to conceal their non-compliance with the blocking statute, risking fines or other sanctionatory measures, but concealing it makes them run still a little bit further. This is the danger to which we are confronted politically, and also for the correct functioning and non-biased functioning of the internal market of the EU. Moreover, the situation of the operators has significantly changed since 1996 due to the increased reliance on global infrastructure and value chains, and the strong exposure of EU operators to third countries. In order to tackle these perceived inadequacies, the Commission on January 19th of this year has presented a new strategies to stimulate openness, strength, and resilience of the EU economic and financial system for the years to come. This strategy aims to enable Europe to play a leading role in global economic governance while protecting the EU from unfair and abusive practices. One of the pillars of the strategy is the development of a stronger policy to tackle the unlawful extraterritorial application of unilateral sanctions and other measures by third countries. In order to do so, the review of the blocking statute is now due and required. So, the Commission is currently considering an amendment, as I said. There was a significant exchange during the last months with public and interested bodies and companies in the matter. The adoption of the proposal is expected for April 2022, so time is now accelerating. It's a complex endeavor. The consultation with the stakeholders was closed on 4th of November 2021, so just 1 month ago. And we received 86 replies, signaling a non-insignificant interest. The majority of these replies confirm the need of a reinforcement of the measures and simplification of the procedures. The changes that are being considered are twofold. And apologies if I'll not enter into an excessive degree of detail at this point in time. First of all, because of confidentiality reasons. And second, because it is possibly a little bit too early to pronounce ourselves on this. So I give you the tendencies, and maybe you will be able to interact during these 2 days in order to improve the thoughts of those who are working presently on this matter. So first changes, first bulk of changes, streamline the application of the current provisions of the blocking statute. So the main objective is to simplify the authorization procedure to reduce the burden on EU operators in order to increase its compliance. The simplification would also apply in relation to the procedures to block recognition of foreign decisions and judgments at national level, and to allow EU operators to recover damages. So we want to make this easier, simple, including to recover damages. Other changes may be required in light of the expected judgments of the EU courts, and they are considered. I don't need to rehearse what I said about these cases. The second change that is considered is introduction of new tools to increase deterrence, the other part. As part of this process, the Commission is considering additional measures to increase deterrence if needed to counteract the secondary sanctions, as well further tools to shield EU economic operators under their legitimate actions. That is what is considered at present. Again, I cannot give you any details at present. Would be an instrument to counteract coercive actions by third countries, focusing on broader problems of foreign coercion of EU countries, but that does not address specifically extraterritorial sanctions. This different initiative is there nevertheless consistent with the reinforced deterrence under the blocking statute. So this will make a sort of a systemic approach to the matter. I am coming now to the end of my presentation. In conclusion, the US application of illegal extraterritorial measure presents not only a challenge in political terms and economic terms, but also in legal terms. The economic operators are actually confronted to an extremely difficult job, and we need to protect them on the one hand, to secure them on the other hand, and to help them continue their legitimate trade. So the objective is now to become stronger, but easier, more effective, and more just in protection of our operators and our citizens. Dear Tom, participants, thank you very much for having invited me to this conference.